Mike's.
Yeah. Now we gotta be on our best behavior,
You are live.
right?
Mics are on.
Okay, I'd like to bring this meeting to order. This is a hearing of the Committee of Adjustment for the Town of Pelham. Everyone present will be given an opportunity to comment on the applications being heard. Please address your comments and questions through the chair. This public meeting has been called to satisfy requirements of the Planning Act and Council bylaws. Notice of this meeting has been given by prepaid first-class mail to all persons listed as owners in the last revised assessment roll within 60 meters of the subject properties. In addition, a public notice sign has been posted on the lands. Agencies commenting on application may request that certain conditions be imposed should an application be approved. Voicing objections to these conditions will not adversely affect the committee's decision. The purpose of the application and relative correspondence will be heard, following which the applicant will be given the opportunity to address the application. Any person concerned with the application will then be given an opportunity to speak. Please state your name and mailing address for the record. At the conclusion of the discussion, the committee will render a decision and advise of any applicable conditions. Specific wording for conditions will be determined by the committee following the public portion of this hearing. All interested parties are invited to be present. Copies of decisions will be mailed to the applicant or agent and to any other person who files a written request. There are colored forms for this purpose which are available on the back table. Any person, corporation, or public body has the right to appeal either the decision itself or the conditions of consent to the local appeal body within 20 days of the decision for minor variances and within 20 days of the mailing of the decision for consent applications. I'd like to introduce our panel tonight. On my far left is Brian D. Martell. On my left is John Clausen. I am the chair, Wayne Lockey. Our clerk, Nancy Bozzato, on my far right, and our deputy clerk, Holly Wilford, on my right. Does any member of this panel have a pecuniary interest in accordance with the Municipal Conflict of Interest Act in any of the applications to be considered at this hearing?
I have none, Mr. Chair.
I have none, Mr. Chair.
And neither do I. Are there any requests for withdrawals or adjournment?
None that we're aware of, Mr. Chair.
Thank you. Is there, okay, we'll be on with the first application, A19-218. Would Secretary please, anybody here for that, would you like to come up to this table here and state your name and address for the, if there's anybody here to represent Mr. DeYoung?
I'm Mr.
Both,
John.
both of you or one of you can come up, introduce yourself and your address. And
Just have a seat.
just have a seat there. And
Just state your name for the record, please.
Stephen Michael DeJong, 669 Metler Road, Fenwick, Ontario, LOS 1CO.
thank you.
And Dieter Pickelman, 12292 Lakeshore Road in Wainfleet.
Thank you. Would you read any correspondence, please?
Committee of Adjustment hearing, Tuesday, September 11th, 2018. Application for minor variance. File A19/2018P, Stephen Michael DeJong. Excerpts from Planning Report. The subject land is located on the north side of Metler Road, lying east of Belford Street, and known municipally as 669 Metler Road in the town of Pelham. The minor variance application requests relief from Section 6.1C, max accessory building height, to allow a maximum accessory building height of 5.95 meters, whereas 3.7 meters is allowed. To date, the following comments have been received. Fire Department, no comments. Building Department, all necessary permits are required prior to construction commencing, and a side yard setback of 1.5 meters minimum must be maintained. Public Works, no comments. Niagara Peninsula Conservation Authority, no objections. Niagara Region Planning and Development Services, no objections, provided no living space or washrooms installed. Public, no comments have been received. Is the variance minor in nature? The variance is minor in nature given the rural context, and the structure is oriented in a way which ensures it appears secondary to the primary dwelling. No negative impacts are anticipated by the adjacent neighbors, as good distance buffers the surrounding uses from a slightly taller structure. Is the variance desirable for the development or use of the land? The variance is desirable for the property because it will allow for enhanced personal usage and storage. The adjacent building at 675 Metler Road is situated southwest of the proposed garage, and no adverse impacts are anticipated on any neighboring lands. Does the variance maintain the general intent and purpose of the official plan? The proposed use of a building accessory to a single detached dwelling is permitted in the rural settlement designation of the official plan, and the policy does permit uses which are compatible with agriculture. The increase in accessory building height will not compromise the objective of the official plan. The variance is appropriate given the site's rural context and meets the general intent of the official plan policies. Does the variance maintain the general intent and purpose of the zoning bylaw? The proposed accessory building's height of 5.95 meters is appropriate given the rural context and ensures that the dwelling is maintained as the main use of the land. Ample amount of open space is available on the site. Thus, the increased height will not adversely impact the rural residential nature of the lot or the surrounding countryside. The variance maintains the intent of the zoning bylaw with respect to accessory building massing and sitting. Planning staff is of the opinion that the application meets the 4 minor variance tests laid out by the Planning Act. The subject application is consistent with provincial policies, the regional official plan, and complies with the general intent of the town official plan and zoning bylaw. The following conditions are suggested: that all necessary building permits must be obtained prior to construction commencing to the satisfaction of the town of Pelham chief building official. Obtain the necessary demolition permit for the existing shed accessory building to the satisfaction of the chief building official. That the applicant maintains a side yard setback of 1.5 meters. That no plumbing or living space be included within the accessory building.
Thank you. Does the applicants have any other comments? Anything else? Is there anybody in the audience that would like to comment on this? If not, with the committee, anybody on the committee have any questions, comments?
I have none, Mr. Chair.
I have none, Mr. Chair.
Would you be ready for a motion?
I am, Mr. Chair.
Thank you.
That we approve file A19 2018P on behalf of Mr. DeYoung for the following reasons. The rural context promotes this kind of particular structure as far as I'm concerned, and it's as long as it's secondary to the main dwelling, and accordingly it is. It maintains the general purpose of the zoning bylaw and the official plan, and it does definitely allow for personal usage, which is great. It's granted without prejudice to any other application for the town of Pelham. No objections have been heard from commenting agencies or the property owners that abut the property. And we have considered written and oral comments, and we agree with the minor variance report analysis and the recommendation that the application meets the Planning Act tests for this particular minor variance. Of course, there are conditions. Number one, that you obtain all the necessary building permits and the demolition permit for the existing shed. You maintain the setback that has been asked for, the 1.5, and that no plumbing or living space to be included within this accessory building.
Thank you. Do I have a seconder for that motion?
I'll second that.
Thank you, John. All those in favor of the motion? Passed. Good to go.
Okay.
Thank you.
Thank you for coming in.
Or,
You have to wait. Is it,
No, you can go, you can leave the room
yeah,
now.
you can
Yeah, but
leave.
there's a 21-day appeal.
Yeah.
right?
Yeah.
Okay.
Mr. Chair, there is a 20-day appeal period from the day of making the decision, which is today. The appeal period will conclude October 1st, and then you could get your building permit after that. I do just want to point out for the record, though, that the drawing shows a setback on the westerly side, westerly property line of 1.46 meters. There will be the requirement to maintain in accordance with the bylaw there. Okay?
Yeah.
thank you.
Okay, thank you.
On to file B3 218P for Custom Vintners Incorporated. The representative, please come up, state your name and address.
My personal house address or this address?
Whatever you like. Where would you like the decision mailed to?
Yeah, I think I'll do it where the decision needs to be made. So Paul Speck, representing Custom Vintners, which is the company that we own that owns this property. And it is 1420 Pelham Road.
Thank you. Would the secretary care to read any correspondence, please?
Application for consent, file B3/2018P, Custom Vintners Inc. The subject parcel, shown as Part 1 on the attached sketch, has 21.03 meters of frontage on the south side of Pelham Road, lying east of Effingham Street, known municipally as 1420 Pelham Road in the town of Pelham. Application is made for consent to convey 0.18 hectare of land, Part 1, to be added to the abutting property on the east, Part 3, municipally known as 1390 Pelham Road, for continued residential use. Part 2, 1420 Pelham Road, is to be retained for continued agricultural use. Note, the boundary adjustment will facilitate the installation of a replacement private septic system to service a farmhouse on 1390 Pelham Road. To date, the following comments have been received. Bell Canada, no comments. Building Department, no comments. Public Works, no comments. Niagara Region Planning and Development Services, no objections. The required regional private sewage system permit for a shallow buried trench system to service the property at 1390 Pelham Road needs to be obtained and finalized after the severance is finalized through the land consolidation. Niagara Escarpment Commission. A Niagara Escarpment Commission development permit application will be required. A final site plan for the new septic system with respect to OBC standards and a permit through Niagara Region. No archaeological concerns as the lands are previously disturbed. Planning is of the opinion that the proposed boundary adjustment will correct a conveyance for legal and technical reasons, which will not result in a creation of a new parcel or additional development. In planning staff's opinion, the application is consistent with the provincial policy statement and conforms with the provincial, regional, and local plans. The following conditions are suggested: that Part 1 merges in fee with Part 3 of the provided sketch. Provide the Secretary Treasurer with registrable legal description on the subject parcel, together with a copy of the deposited reference plan, if applicable, for use of the issuance of a certificate of consent. Provide the final certification fee of $380 payable to the Treasurer, Town of Pelham, be submitted to the Secretary Treasurer. All costs associated with fulfilling conditions of consent shall be borne by the applicant.
Thank you, Holly. Do you have any comments, questions? Anything you'd like to say?
Well, I think it's fairly straightforward. It's a help house where it's an old severance, and to put a new, more updated septic system in it, the old severance, which is 40 or 50, at least 50 years old, maybe older. The severance, the existing property's too small, so luckily we own the vineyard land around it, so we're just increasing the size so we can put an updated septic system in. That's basically what it is.
Thank you. Anybody in the audience would like to comment? If not, would the committee, anybody on the committee like to comment or any questions?
I have no questions.
I have none. I looked at the site, it looks pretty straightforward.
Thank you very much. Would you be ready for a motion?
I'll make a motion that we allow the part one to merge with part three as described, and that they provide a reference plan, legal description, and a certification of fee to Secretary Treasurer. And we base our decision on the other. We want to facilitate the installation of a replacement septic system to service a farmhouse on 1390 Pelham Road. And that the applicant is aware that all necessary Niagara escarpment and regional permits will be required. And this conforms to the policies of the town, region, and province and complies with the town's zoning bylaw. No objections were received from any of the agencies or neighboring properties. And the decision is rendered having regard for the provisions of section 5124 and 5125 of the Planning Act as amended. The Committee of Adjustment we've considered all written and oral submissions, and we find the subject to the conditions of provisional consent. This application meets the Planning Act criteria, is consistent with the provincial policy statement, and complies with the growth plan, the Niagara Regional Official Plan, and the Town Official Plan. So be moved.
Thank you. Do I have a seconder for that motion? Thank you, Brian. All in favor of the motion? It's carried. It's, your application is granted. You have 20 days from the mailing of the consent before you should start your
Okay, great, thank you very much.
system. Thank you for coming in, Paul.
And have a good harvest.
Yeah. Okay. File B5, 218. Ollie, would the applicant come up, state your name and address, please?
Stephen Kaiser, address is 1541 Hay Street in Fonthill.
Thank you, Holly.
Application for consent, file B5/2018P, Brian V. Sullivan. The subject parcel, shown as Part 2 on the attached sketch, is an interior parcel of land situated 61 meters east of Station Street, lying south of Highway 20 East, Regional Road 20, being part of Lot 7, Registered Plan 717 in the town of Pelham. Application is made for consent for a partial discharge of mortgage and to convey 2,826 meters square of land, Part 2, to merge with the abutting property to the south, Part 3, 1419 Station Street, for continued residential use. Part 1, 1423 Station Street, is to be retained for continued residential use of the single detached dwelling. Note, the boundary adjustment is intended to facilitate rear yard land consolidation for a future draft plan of subdivision in East Fonthill. To date, the following comments have been received. Building Department, no comments. Public Works, that a comprehensive overall lot grading and drainage plan for all parcels to demonstrate that the drainage neither relies nor negatively impacts neighboring properties, and that all drainage will be contained within the respective lots, be required. That the applicant confirm that no existing utilities currently cross the proposed new property line. Should any services cross this new property line, the applicant will be responsible for costs associated with the relocation and/or removal. That the applicant provide a written acknowledgement that the owner will be responsible for payment of the front-end contribution payable to the town of Pelham for the East Fonthill Storm Water Management System oversizing. This apportionment will be in the amount of $35,109 for 1423 Station Street, Parts 1 and 2, and $35,061 for 1419 Station Street, Part 3, totaling $70,170, and further that the owner will advise any future purchasers of the land of this requirement. The existing outlet for the road cross culvert that was previously filled in must be reinstated, free and clear of all encumbrances. Niagara Region Planning and Development Services, no comments. Planning staff is of the opinion that the proposal applies current planning and development goals dealing with appropriate infill development, making more efficient use of the existing urban lands where suitable to do so. The severance will better position the land for future subdivision development in a more efficient manner, which will not negatively affect the developability of the balance of the lands. The proposed severance should not negatively impact the surrounding neighborhood with regards to traffic, privacy, and stormwater runoff. The remnant lands will continue as a single detached residential use until such time as the landowner explores alternative development options. The planning staff's opinion that the application is consistent with provincial policy statement and conforms to provincial, regional, and local plans. The following conditions are suggested. Part 1 merges in fee with Part 3 of the provided sketch, submits an overall comprehensive lot grading and drainage plan for both parcels, demonstrating that the drainage neither relies nor negatively impacts the neighboring properties and that all drainage will be contained within the respective lots to the satisfaction of the Director of Public Works or designate. Confirm no existing utilities cross the proposed new lot line. Should any services cross the new lot line, the applicant will be responsible for costs associated with the relocation and/or removal. The existing outlet of the road cross culvert that was previously filled in must be reinstated, free and clear of all encumbrances. Provide the front-end contribution payable to the Town of Pelham for the East Fall Hill Stormwater Management System oversizing. This apportionment will be in the amount of $35,109 for 1423 Station Street, Parts 1 and 2, and $35,061 for 1419 Station Street, Part 3, totaling $70,170. Provide the Secretary-Treasurer with a registrable legal description of the subject parcel, together with a copy of the deposited reference plan, if applicable, for use of the issuance of the Certificate of Consent. Provide the final certification fee of $380 payable to the Treasurer, Town of Pelham, be submitted to the Secretary-Treasurer. All costs associated with fulfilling conditions of the consent shall be borne by the applicant.
Thank you, Holly. Do you have any comments, questions?
Yes, I do. Mr. Chair, first off, I believe there was another condition, or a condition to the front-end agreement that was, staff have supplemented or added in, substituted.
Yes, I think there.
That includes it, that's correct.
So is that the condition there now?
That's correct.
I'll just back up to that slide.
That's not the condition, I understand.
Madam Clerk, if,
So what, the most recent information that the Committee of Adjustment administrative staff received is that the applicant provide a written acknowledgement that the owner will be responsible for payment of the front-ending contribution payable to the Town of Pelham, and then the amounts are shown there. That was in an email from Shannon LaRocque, our senior planner.
Correct.
Good. Mr. Chair, if I could speak specifically to that condition as I've been read and my blood pressure up ever since I read it on Thursday. We attended, or I attended a pre-consultation meeting in regards to this, which is really a boundary adjustment to join one piece of what's now agricultural land in a secondary plan to a piece that my wife and sister-in-law own in the same secondary plan area. I should note that the first 200 feet that are being kept or retained by Mr. Sullivan, who I'm acting as agent for, are not in the secondary plan area, have a zoning and an official plan amendment, and have been in the town boundaries for years. I've been part of this industry for 50 years. I've past president of the Ontario Home Builders Association. I've been qualified as an expert witness all the way to the Supreme Court of Canada in regards to this industry. So when these conditions were mentioned, my back got up when they were mentioned at the pre-consultation meeting, because I've been involved in this process, this secondary plan, for years. I marched the secondary plan through process on behalf of 5 developers. We got the secondary plan approved, working with the town. The town reimbursed the group that I represented over $1 million for their work and studies that they did on the plan. My client, Fonthill Gardens, has worked with the plan in terms of a dual development that you'll know well down at the front of fronting on Highway 20, the Food Basics Plaza. And so I'm well cognizant of the goings-on within the development. The said fronting agreement for the stormwater pond is the stormwater pond at the corner of Rice Road and Port Robinson Road. It's just been constructed. There's a number of houses that have gone up there. The deal, the town, I'm not going to give exact because I don't know exact, but the River Realty, the developer, was given for their portion development charge credits, essentially, that they used to use for the portion of the pond that they paid for. The pond is hugely oversized because it takes in all the remainder of the land within that quadrant of the secondary plan up to the property we're talking about. But I've noted to the town that their biggest gaping hole right now is they do not have a front-ending agreement in place that actually sets out these fees or how they will be collected, and hasn't gone through council. So essentially, this condition is totally ultra virus. It's without authorization, and I found it offensive because with a group of property owners, we're assembling the land, as the clerk has noted, and the front pieces have a different zoning, and they've been in the urban boundary. So to back up, as we were working through the secondary plan process for 5 years, the town at the table in this building brought in their drainage superintendent and their expert, John Spreet, and we looked at how we'd collect the money for that pond, and it was thought to do it through the Drainage Act. Well, unfortunately, through the Drainage Act, the number of properties that actually flow downhill from almost as high up as Hayes Street coming down, all those properties have to be part and sign off on the Drainage Act, basically, and can be an appellant as you move through the process. That was thought to be too complicated. So what the town did was ask Upper Canada to make a map and calculate the area of the properties that flow in not just the secondary plan, but the fronts of these lots on Station Street. My position is, and will be when this ever comes to council, not only on myself, but to the group who are assembling lands, that yes, we absolutely believe we will need to contribute to the stormwater pond for the lands that are in the secondary plan. But we will not, or do not believe we should have to contribute for the lands that are outside the secondary plan. Otherwise, the town needs to go by way of the Drainage Act as opposed to simply waving a wand and charging those areas that seem to be in the same general area. It just doesn't work. So my point is, and I've argued this since Thursday, the conditions definitely soften, but the condition still contains exact amounts and notes that Part 1 will be charged also. Well, Part 1 is not in the secondary plan. So I discussed with the clerk. My first would be that the sentence that notes any amounts be struck, because there is no formal piece of legislation, no bylaw, no fronting agreement, no authority backing to ask for formal amounts at this time. Nothing is in place. Unfortunately, you have to take my word on that. When you have a park dedication fee, there's a park dedication bylaw. When you have a development charge, there's a development charge bylaw. When you have a fronting agreement, it's laid out precisely in a fronting agreement. At this point in time, there's no fronting agreement in place. I wholly acknowledge, and I've encouraged the town treasurer and CAO that they need to get this fronting agreement in place, because it's a gaping hole for them in terms of funding a fiscal responsibility that they've taken on now in terms of this stormwater pond at the corner of Rice Road and Port Robinson Road. So I'm not abdicating responsibility. I just don't want to tie my hands or Mr. Sullivan's hands in terms of fees that I don't think the town has any authority at this point in time to put across these lands. So I would ask that anything involving a cost be struck, and I'm fine with the clause after that.
Yes. Any comments from the committee?
Well, I'll say, I mean, I've heard Mr. Kaiser, but I'd like to hear the other side from our town as to what their response is gonna be to you. And I'm not prepared to make a decision based on what you say. I want the other side to be heard too.
Mr. Chair, if I could, I've asked the town to be here today, and I'm fully willing to adjourn this hearing to have the town here.
Nancy, any comments?
Through you, Mr. Chair, the matter has been back and forth between our planning staff, our public works staff, and Mr. Kaiser for a number of days. And I think there is some difficulty in that the town installed the infrastructure, so a front-ending agreement may not exist right at this time, but it would be an agreement between the town and the town. So planning and public works are definitely supportive of the condition as worded. I have suggested to Mr. Kaiser that the words, the apportionment is estimated to be in the amount of 35,000 and 35,000. That gives him the ability to negotiate those fees
And I'm
with,
fine with that.
with the appropriate departments, but to completely abdicate and not impose the conditions would certainly risk an appeal by the town because they are confident that those fees are applicable, or at least some fees.
Any other comments from,
I'd have to agree with John. I'd like to hear the other side of this. I want more clarification. And I think an appropriate dialogue can take place where I would feel confident in making a decision one way or the other. And so perhaps we should have this deferred this time.
I guess, Mr. Chair, to the clerk's comment, if the, I know, I'm not asking you to accept my word wholeheartedly. With the addition of the word approximately, I think I could live with that.
you could live with that?
Yes.
That depended on you reaching an agreement to the satisfaction
But
of the
gives some
town?
flexibility and doesn't entrench the exact dollar amounts.
Through the chair, are we allowed to negotiate with someone wanting a fee? Or how we're gonna
No,
put that?
we would not negotiate a
I
fee.
didn't
It
think
would
we'd
be
have the power
between
to do
the
that.
town. I would, personally, I would like to see a fee agreed on before we passed it.
I would like to have someone from the town that has the authority to sit with him and say, okay, this is what we agreed on, and then we do the application.
Through you, Mr. Chair.
Yes.
The committee doesn't have the benefit of Mr. Kaiser's suggestions with regard to the Drainage Act. The committee doesn't have the benefit of the background information for the infrastructure that was in place. So if the committee does decide to entertain an adjournment, I would suggest respectfully through you, Mr. Chair, that you make it conditional that the committee be provided with detailed information from the Public Works Department and the Planning Department before rendering a decision moving forward.
That would be acceptable to me. Is that acceptable with all of the committee?
Yes, and also the adjournment that they settle this fee situation at the same time.
Yeah, that's what I would imagine. Yes.
Well, if I could, Mr. Chair, through you, the committee members, the fee situation can't be settled until the town enacts a front-ending agreement. And this clause cannot act as impelling a front-ending agreement because a front-ending agreement isn't in place. So a front-ending agreement has to be an act of council.
If that's correct, I would think we should adjourn until you have a front-end agreement or until you agree to.
Process, isn't it?
Pardon?
That's a, is that not a complex, long process to get that?
Through you, Mr. Chair, I am not 100% certain that a front-ending agreement is the resolution to this. This has not been vetted through our legal counsel at this point in time. I only became aware of the issue this afternoon. So it sounds like there's still a little background to be done on this particular condition. And rather than risk an appeal of the condition or the decision or one way, it probably would be prudent if the committee were to adjourn the hearing, encourage that dialogue between the town and the applicant, and then a fulsome report be returned back to the committee for consideration at a future meeting. This hearing panel would be seized of the application, so we'll want to work quickly because the term, as we know, there's an election coming forward, and this committee's term will end November 30th or until your successors are appointed. So you do have that provision under the Planning Act that the committee does stay until the new committee is appointed, but we are dealing with some time sensitivities here as well. So the other option would be, of course, that when it does come back, if it doesn't get resolved in time for this term, it would just be a hearing de novo where a new panel would hear all of the evidence from the beginning.
Thank you. I would be in agreement with that we should adjourn until further. Everybody in favor of that? Do we need a motion that,
Preferred, yes.
yeah, I'd entertain a motion of adjournment?
I'll move that we entertain the motion of adjournment until we're provided all the information so we can make a well-informed decision on this matter. We don't have enough at this point, so be moved.
Thank you. Seconder?
I second that.
Thank you, Brian. All in favor? Carried. Let's adjourn until,
Thank you, Mr. Chair. I appreciate that, and I understand your position. As I said, I found out about the condition on Thursday. The Director of Planning is away on vacation, not her fault. We don't have a Director of Public Works right now. The CAO is acting. His hands are full with the opening of the community center later this week. And I was away trying to do this over the phone. So that's where we're at. So I think we've come to the best solution for now. And hopefully we can bring you both town and applicants singing from the same song sheet when we re-adjourn.
thank you very much.
Thank you.
Thank you for coming in.
So the application will be adjourned, sine die, with the hearing panel seized of the application.
Okay, thank you.
Thank you.
Thank you very much. Okay, do we have minutes of approval? Minutes for approval.
Yes, you do, sir.
Yeah.
From August 14th, 2018.
Okay. Do you have if you've read it, have you
Yeah,
have a motion to accept those minutes?
I'll move that we accept the minutes as written.
I'll second it.
Thank you. All in favor? Done. And call for adjournment.
I'd like a little bit of discussion on that last application. A little clarification before we adjourn,
Sure.
unless you have to go and pick some
No,
grapes
no,
or something.
no.
Oh, Jesus. I-
Is the-
Okay,
is
do you want
the
it
mics off?
recorded? Yeah.
No,
Yeah,
Are we at,
adjourn.
adjourn first.
We're
Yes,
adjourned.
right, and then you can.
Now
shut
we're
the
gonna-
mic off. Yeah.
I'll-
Adjourn
One moment,
first and
please.
then